Good evening, I'm Chris Wallace in for Brett Baer. President Obama's use of recess appointments to get around the requirement for Senate approval was illegal in some cases. That was the unanimous ruling today by the Supreme Court. We have Fox team coverage. Wendell Goler at the White House has reaction to the decision. But we begin with Shannon Bream at the Supreme Court tonight with another case of presidential overreach. Good evening, Shannon.
Hello, Chris. Well, all 9 justices agree when the president decided to name 3 people to the National Labor Relations Board. At a time the Senate said it was in session, he overstepped his constitutional boundaries.
He went too far. This is a great day for America.
In a unanimous opinion, the Supreme Court said President Obama exceeded the limits of his executive power when he decided back in January 2012 to bypass the Senate and name 3 new members to the National Labor Relations Board. On December 17, 2011, the democratically controlled Senate, by unanimous consent, had adopted a plan to keep the Senate continually in session, gaveling in for so-called pro forma sessions twice a week. Writing for the court, Justice Stephen Breyer found that mechanism enough to keep the president at bay. Quote, "We hold that for purposes of the recess appointments clause, the Senate is in session when it says it is, provided that, under its own rules, it retains the capacity to transact Senate business. The Senate met that standard here."
There's a lot of danger in the chief executive having too much power. We need a Congress that can have the ability to push back on the president. We need to remind the president routinely that he's not a king.
But Senate Majority Leader Harry Reid says the court got it wrong. Quote, "Since President Obama took office, Senate Republicans have done everything possible to deny qualified nominees from receiving a fair up or down vote. President Obama did the right thing when he made these appointments on behalf of American workers." And even though all 9 justices agreed with the court's ultimate holding, 4 of them disagreed with the majority's sweeping opinion, which held that the president does have broad recess appointment powers during the Senate's intra and intersession recesses, whether the vacancy in question arises before or during that recess, an interpretation far beyond what has previously been afforded to the executive branch. Writing for those 4, Justice Antonin Scalia said, quote, "The Constitution's text and structure unambiguously refute the majority's freewheeling interpretation of, quote, the recess. It is not plausible that the Constitution uses that term in a sense that authorizes the president to make unilateral appointments during any break in Senate proceedings, subject only to hazy, atextual limits crafted by this court centuries after ratification." Another test of the administration's power will come on Monday, 10 o'clock Eastern. That's when we'll get the decision in the case challenging the HHS contraceptive mandate that stems from the health care law. Devoutly religious business owners say if they're forced to provide cost-free access to contraceptions they actually believe can trigger abortions, well, the government will be trampling on their religious freedom. Chris.
Shannon Bream reporting from the Supreme Court. Shannon.